Hello everyone, my name is Satvir Singh and I am a faculty for Polity Governance and Internal Security at Vajiramandravi, and today we shall be taking the consideration of an important topic of our GS paper 3 in Internal Security, that is Armed Forces Special Powers Act. If we go by Armed Forces Special Powers Act, over the period of time, the Act has been criticized on the grounds that it has resulted in the sheer violation of the basic human rights, as well as it has failed to uphold the dignity of the basic human rights as well as fundamental rights. The Act has been termed as a black law, has been termed as a Draconian Act on a number of occasions because of the sheer violation of the human rights, as it can be observed in case of T. Manorama killings of 2004, as well as in case of Patribal encounters, whereby an SIT was appointed by the Honorable Supreme Court to investigate the Patribal killings over there. The Act has also been criticized on the grounds that it is having a legal immunity clause, and that clause allows the men in uniform to take unwarranted decisions, as they cannot be prosecuted without the approval of the union government in case of any actions that have been taken by them in accordance with the powers that have been conferred on them under Armed Forces Special Powers Act. So if we can trace the historical background of the Act owes its origin to the year 1942, whereby in order to counter the situations that may arise out of the arrest of the major leaders in Quit India movement, the Viceroy of the time, Linlithgow, promulgated an ordinance, Armed Forces Special Powers Ordinance. Now, this Armed Forces Special Powers Ordinance, it was also referred as, or it was also regarded as, a license to kill, because it gave unwarranted set of powers to the men in uniform without any accountability. Looking at the efficiency in controlling the situation during the Quit India movement, it was also continued in 1947 when the country was battling with the partition riots. So it was also extended to the four major states of the country, namely United Province, East Bengal, East Bengal, as well as Assam. But you see, the security situation became very tensed even after independence. After independence, when the northeastern states of the country, they were battling with the situations of insurgency, like in 1952, Fizo, the architect of Naga insurgency, he declared independence from India. He formed his own army, Naga Federal Army. He has formed his own country, Naga Federal Republic. He declared independence from India. So, for the first time, to tackle the situation, in 1953, an order was passed called Assam Maintenance of Peace Order. Assam Maintenance of Peace Order. It was passed for the state of Assam. But unfortunately, it failed to contain the insurgency situation in the Assam, more specifically in the Naga Hills district. So in 1955, another act was enforced, that was Assam Disturbed Area Act. Assam Disturbed Area Act. It was enforced in the year 1955. But sadly or unfortunately, this act also failed to contain the insurgency situation in Naga Hills district. So finally, it was the time for the Armed Forces Special Powers Ordinance. Armed Forces Special Powers Ordinance. So this was not a law in the post-independence era. It came as an ordinance in the year 1958. In the very same year, more specifically in September 1958, it took the shape of Armed Forces Special Powers Act. It took the shape of Armed Forces Special Powers Act, and slowly and gradually, looking at the severity of the security situations in the northeastern part of the country, it was slowly and gradually extended to the other northeastern states. After northeastern states, it was the term of Punjab and Chandigarh, where Punjab was battling with the menace of Khalistan insurgency. During Khalistan insurgency, in 1983, Armed Forces Special Powers Act was also enforced for the entire state of Punjab and Chandigarh. Now, when this act arrived in the state of Punjab, there were two modifications which were made over there. There were two modifications in Armed Forces Special Powers Act, like subsection E was added to section 4, as well as a new section called section 5 was also added to Armed Forces Special Powers Act. Subsection E to section 4. Now, subsection E to section 4, it allowed the men in uniform or the security personnel to stop, check and seize. To stop, check and seize any vehicle if it is carrying the proclaimed offenders. Proclaimed offenders means Khalistani insurgents. Apart from that, section 5, it allowed the men in uniform, to break open any lock if the key is withheld. That means if the key is not available for any of the lock, it can be broken down by the men in uniform. Now these two sections, these two additional sections were the one which were added to Armed Forces Special Powers Act when it was enforced in the state of Punjab. Now, insurgency came to an end in the year 1997 in Punjab, and in 1997, the Armed Forces Special Powers Act, it was revoked from the entire state of Punjab. But Chandigarh, the Union Territory, it continued to be under Disturbed Area Act till 2012. With respect to Disturbed Area Act, one thing that we should remember is that Disturbed Area Act is basically a law of the state. That means whole of the authority with respect to Disturbed Area Act, its enforcement, regulations, etc., it is lying with the state government. Now that is another aspect that the state can confer or can give this power to the central forces over there. But overall the authority, it rests with the state government over there. Or in another words, what we can say is that this Armed Forces Special Powers Act or this Disturbed Area Act can be termed as Mini Armed Forces Special Powers Act. Now, after Punjab, it was the term of Jammu and Kashmir, where in order to tackle the unprecedented rise in the militancy activities in the valley, it was enforced in 1990, and it is still continuing in Jammu as well as in Kashmir over there. Now, the act has been criticized because of a number of controversial sections. The act has been criticized because of a number of controversial sections such as section 3. The section 3, it is one of the very controversial section of the Armed Forces Special Powers Act. It allows the governor of the state, or the central government or the union government, to declare any area as disturbed area. And then only Armed Forces Special Powers Act can be enforced. Now, so remember that the Armed Forces Special Powers Act cannot be enforced in an area until and unless it has been declared as a disturbed area. Now the thing is, how do we define this disturbed area? The disturbed area, in accordance with the section 3 of the Armed Forces Special Powers Act, is defined as any such area where the law and order machinery cannot function in accordance with the constitutional spirit over there, or the civil administration requires the intervention on part of the armed forces. That means the use of armed forces becomes necessary to aid the civil administration in a disturbed area. And with respect to this disturbed area, please remember that it is not always that whole of the state need to be under the disturbed area with respect to section 3 or with respect to Armed Forces Special Powers Act. That means even a district can be declared as a disturbed area, or a smaller stretch or a locality can also be declared as a disturbed area. Or to be very specific, we can say even a stretch of 100 meter or so can also be declared as a disturbed area depending upon the severity of the security situation over there in accordance with section 3. Now, so Armed Forces Special Powers Act can only be enforced in the disturbed area. So there is a lot of subjectivity over there in the definition of the disturbed area. Apart from that, that totally depends upon the discretion of the governor or union government or the administrator of the union territory. why this section is criticized over there is that the state governments have their limitations. The state governments have their limitations with respect to section 3. Limitations as of the state with respect to disturbed area can maximum make its recommendations. The state with respect to the disturbed area can maximum make its recommendations. Whether to accept those recommendations or not to accept those recommendations, that will totally depend upon the discretion of the governor, union government, administrator of the union territory, as the case may be. Like one example that can be taken for the purposes after the Mon district killing in the state of Nagaland, the Nagaland cabinet, they passed a resolution and they requested the central government to revoke Armed Forces Special Powers Act from the entire state of Nagaland. Within no time, just within a span of 24 hours, the central government decided to extend it by further 6 more months over there. So that is totally the discretion of the union government and these authorities with respect to the declaration of an area as disturbed area. Section 3. Now another controversial section in Armed Forces Special Powers Act is Section 4. Section 4 basically talks about the powers given to the men in uniform. Powers as of what? Powers like to shoot even to the extent of causing death. To shoot even to the extent of causing death. Apart from this, arrest without warrant. Arrest without warrant. Then search without warrant. Search without warrant. Then to destroy any fortification. To destroy any fortification or complex if it is used to attack the men in uniform, if it is used to attack the security personnel. Apart from that, if it is used as a hideout by the terrorist, or it is used as a training camp, or it is used as a training camp or for the purposes of training on part of the terrorist organization, on part of the terrorist. Now, so this section 4 gives huge amount of power to the men in uniform, and simultaneously the criticism for section 4 is what? That it has resulted in the violation of the human rights, especially Article 22. Article 22 of the Indian Constitution guarantees certain set of the rights to the accused, like right to be produced before the competent court within 24 hours of arrest. Apart from that, right to be represented by the attorney of his own choice, right to know the reasons of arrest. Apart from that, this reasons of arrest to be written in a police diary. But at the grassroots level, if we go by the observation, on a number of occasions, these rights are the one which have been violated under Section 4 of Armed Forces Special Powers Act. Then another criticism, in fact, one of the most controversial section or clause of Armed Forces Special Powers Act is Legal Immunity Clause. Legal Immunity Clause. The Legal Immunity Clause of Armed Forces Special Powers Act says that the men in uniform cannot be prosecuted until unless the prosecution has been approved by the union government. Until unless the prosecution has been approved by the union government. State does not have any say in the prosecution. This clause has been the major bone of contention between the human rights activists as well as the men in uniform or the government authorities. Now, certain set of criticism that we see for the Armed Forces Special Powers Act includes certain set of criticism on part of Armed Forces Special Powers Act includes, like, it has resulted in the violation of human rights. It has resulted in the violation of human rights, as can be seen in case of T. Manorama killing or T. Manorama encounters. What was the case of T. Manorama killing? T. Manorama killing, there was allegations on the Jawans of Assam Rifles that she was brutally dragged from the house, and after that there were allegations that she has been raped and she was a victim of the custodial death over there. Now, after the T. Manorama case, another case that has happened over there was Pathribal encounters. in pathrival killings or in pathrival encounters, an SIT was appointed by the Honorable Supreme Court, and the SIT was, you can say, under CBI, the SIT was formed, and the SIT in the charge sheet that was submitted to the Honorable Court said that it is nothing except cold-blooded murder. It is nothing, these killings are nothing except cold-blooded murders. Finally, the accused, they were released on grounds of lack of evidence. Apart from this, another criticism is with respect to Article 22, as we have just now seen, that it has resulted in the violation of a number of articles that have been guaranteed under Article 22. Then, it allows the men in uniform to take unwarranted decisions. Allows the men in uniform to take unwarranted decisions, and they behave like judge on the situation, and the life of the individual or the life of suspect is merely at the discretion of men in uniform. It is the sheer violation of principle of natural justice, because everyone deserves an opportunity to be heard over there. It is a sheer violation of principle of natural justice. Apart from that, another criticism that is there for the act is that this act provides legal immunity to the men in uniform. These are the four major areas of criticism, or what we can say is they have been the cause of conflict or bone of contention between the human rights activists as well as the government authorities. Now, as a part of the reforms, there were two committees which were appointed by the government of India, namely the BP Jeevan Reddy Committee of 2005. BP Jeevan Reddy Committee of 2005 was of the opinion that the act is too sketchy, it suffers from a number of constitutional infirmities. In fact, as per the committee went for a very radical remark also. The act is too sketchy, suffers from constitutional infirmities. Apart from that, the act is nothing except an instrument of discrimination, instrument of hate that promotes high-handedness in men in uniform. So, BP Jeevan Reddy Committee was of the opinion that there is a need for comprehensive review of the act. On the very similar line, the Santosh Hegde Committee, the Honorable Judge of the Supreme Court, Santosh Hegde Committee in 2013 also made a very important remark that the men in uniform, they have powers, but the citizens do not have rights. So this is the right time the accountability shall be fixed for men in uniform. In fact, on a number of occasions, the Honorable Supreme Court has also been of the opinion that every person with a weapon in their hand is not necessarily the state's enemy. Apart from that, Honorable Supreme Court has also remarked that there is a presence of state-sponsored violence in the conflict-ridden areas where the citizens are not having the access to even the basic human rights such as justice. The Honorable Court occasionally has also given certain directives like Armed Forces Special Powers Act should be reviewed after every 6 months. The minimum force shall be used under Section 4 of Armed Forces Special Powers Act. And apart from that, there is no concept of blanket protection. There is no concept of absolute immunity over there. Those accused individuals, those accused officials, in fact, they can be tried in the court of laws also. So the right time, in order to conclude, what we can say is that this is the right time the Armed Forces Special Powers Act need to be comprehensively reviewed so that it can be accommodated within the constitutional spirit to maintain the national security as well as the public order, also simultaneously fixing the accountability of the men in uniform over there. So that's all we have for this session over there. Do take very good care of yourself. Have a good day.